I guess I'm trying to figure out what the nature of your argument is. You refer to contract defenses, then you say or a miscarriage of justice exception. In the time you've been up there, you've said the question is whether it's outside the realm of plausibility. You've referred to constitutional violations. I mean, when is it that this would come into play in your view, more specifically?
So hopefully almost never, because courts don't do crazy things like
but I'm asking for a standard.
Sure.
Like, what are we looking to?
The standard is that the easiest and the high-level rule statement is it's subject to contract defenses.
Well, I don't. What is a contract defense? Does that just mean it's against public policy, or are you referring to other kinds of?
Break that down. There are hundreds of years of precedent on very narrow defenses that sound maybe in label broad, but once you take off that label, they all have a thumb on the scale, exceedingly thumb on the scale in favor of enforcement. That's why contract defenses are so rare, and if you go past the restatements, you start reading why they're never applied, including public policy. Public policy, as this court said in Rummery, the first public policy is enforcement of the contract. So you would have to have some really out there public policy that would outweigh that.
Is there anything other than public policy that you're talking about when you refer to contract defenses?
I think the one that makes public policy is a good one because it's rooted in this court's case law. The one that makes the most sense is the one the government asserts, which is frustration of purpose. The government has gotten out of plea agreements in the two cases, both in the Fifth Circuit and the Tenth Circuit, because they said it was frustrated when a defendant didn't do anything wrong, but just got out on collateral relief. Frustration of purpose, why I think it's the best, and that's why I got the standard of outside the realm of plausibility.